Hello, welcome to online orientation for mediation in Orange County. My name is Sarah, and I will be your guide through this orientation. Since this information is important, you will be asked to respond to a few questions as we go along. Mediation is required whenever there is a dispute about child custody or visitation. Mediation focuses on developing an agreement between parents that is in the best interest of the children. Family Code 3161 defines 3 purposes of mediation. The first is to reduce conflict between parents so children can benefit from having all parents in their lives. The second purpose is to develop an agreement that ensures children will have a close and continuing contact with each parent, and to reach a settlement regarding visitation rights that is in the best interest of the children. Some additional goals of mediation are to enhance the understanding of the other parent's point of view, focus on what works best for your children, and to work out the details of your parenting plan. Mediation is conducted by specially trained professionals and is provided at no cost. Mediators will assist you with your parenting plan. We will go into more detail later. However, in general, your parenting plan may consist of how time will be shared during the school year and summer, holiday and vacation schedules, transportation and exchanges, how to address safety issues, and any other important details specific to your situation. You may be wondering, if you already have an agreement or are being represented by an attorney, do you still need to go through mediation? It is still advisable to participate in a court-ordered mediation. Though an attorney is helpful in presenting your agreement to the court, our trained mediators can provide a professional review of your agreement. Ensure all parenting aspects are included and prepare your agreement for the hearing. Welcome back. The mediation process is focused on developing a plan so that both parents have a clear understanding of who is responsible for your child at any given time. Mediators do not discuss any financial-related issues. These are issues that will be addressed by your attorney if you have one, or by the judicial officer at the hearing. We understand that financial matters may influence a parent's ability to compromise and reach an agreement. However, we encourage you to stay focused on the emotional and developmental needs of your child. In addition, mediators are not attorneys, and we cannot provide legal advice. The parenting plan you develop will be created in a collaborative manner and designed to address all aspects of parenting responsibilities. Some important aspects to consider are the age and emotional development of your children. Typically, the younger the child, the more frequent the contact for shorter periods of time. As a child grows older, they are able to tolerate longer periods of time and consecutive overnights with each parent. Another defining factor is the distance between each parent's home. When parents live closer to each other, the child has more frequent access to each parent. This provides more opportunities for parents to participate in the child's day-to-day activities. When the distance between parents' residence is too great, children may experience long hours of transportation and spending extended periods of time away from one parent or the other. This will help determine the frequency of contact with each parent. It is important to think about any special needs your child may have, the different types of activities your child participates in, and any school-related events that may affect the schedule and a parent's ability to get your child where they need to be. Remember, your child is depending on you to maintain as much stability in their life as possible. and continuing in activities they enjoy will help them transition through the separation a bit easier. Finally, parents need to take into consideration any safety issues relating to a parent's ability to care for your child. Some parents will allege alcohol or substance abuse concerns, and this is taken very seriously by the court. Parents may agree to have a statement in their plan, such as, both parents agree not to consume alcohol or any substance that may impair their ability to care for the child or children. Many times having a conversation about safety issues during the mediation session and addressing it in the parenting plan alleviates the concern. If the issue is more prevalent and/or there is a criminal involvement, then the mediator may discuss supervised contact and may also provide resources to assist a parent in obtaining treatment. Welcome back. Now let's discuss the labels of custody. Legal custody refers to the right to make decisions about a child's health care, education, and welfare. Joint legal custody means parents communicate and make decisions together. Sole legal custody means that one parent has the exclusive right to make these decisions. Physical custody determines which parent is primarily responsible for the day-to-day care of the child. This is designated by either joint or sole. Joint physical custody means both parents share significant periods of physical custody that assures the child will have frequent and continuing contact with each parent. This does not necessarily mean an equal timeshare, and one parent may still be designated as the primary caregiver. Sole physical custody means that one parent provides the primary residence and supervision of the child, and the other parent may have a court-ordered visitation. Parents who have temporary or permanent domestic violence restraining orders can still participate in mediation. The court will determine the label of legal and physical custody. The mediator may assist parents in developing a safe visitation plan that may include a professional monitor or supervision by a trusted family member. In addition, exchanges can be arranged through an agency or third party to prevent any potential conflict between the parents. When parents come to mediation and there is a current restraining order, certain precautions are mandated. Family Court Services has a separate waiting room to prevent the parties from having contact. The mediator will also meet with the parents separately and go back and forth between them to facilitate an agreement. The protected party may have a support person with them during mediation. Support persons may not be the party's attorney and/or significant other, and they may not verbally contribute to the mediation conversation. Orange County is a confidential model of mediation. What this means is that if parents do not reach an agreement, the mediator does not provide recommendations to the court for visitation and custody, nor do they communicate what happened during the mediation session. A simple memo is sent to the court indicating the parents participated in mediation. However, they did not reach an agreement. The parents are directed to attend the hearing to discuss their case with the judicial officer. There are some exceptions to confidentiality. Mediators are required per Family Court Services policy to report any suspicion of child abuse or a person's intent to harm themselves or another person. In some cases, when parents are currently involved with social services or have been within the past year, the mediator is able to obtain information from social services that may be helpful in developing a safe contact plan for the children. Court-employed mediators working in Family Court Services are required to have a master's degree or higher in behavioral science, such as psychology, social work, marriage and family, or child counseling. Mediators have a minimum of 3 years post-master's experience, extensive knowledge of child development, the court system, and community resources. In addition, court-connected mediators are required to complete 12 hours of continuing education annually, with 4 of these hours focused on domestic violence. Mediation only involves the legal parents or guardians and the mediator. Each parent is given an opportunity to present their proposal for how they want the timeshare and custody of their child to be. Usually the parent who filed the current request for court orders generally speaks first. The mediator will facilitate the conversation between the parents to negotiate and compromise in order to help you reach an agreement. Remember, the mediator is a neutral person and does not take sides. It is the mediator's job to provide education and suggestions to assist parents with their parenting plan. In preparing for your mediation session, it is important to keep an open mind and come ready to discuss different options for sharing time with your child and the other parent. Mediation is not about winning or losing. It's about problem solving. Remember, this is about your child's best interest, and children do best when both parents are involved. Take time to consider the other parent's proposal. Offer another solution rather than rejecting it completely. Even minor compromises can go a long way in developing a plan that both parents are willing to live with. Try not to place blame or focus on the negative feelings you may have about the other parent. We understand this is a difficult and emotional time. However, letting your emotions and past history influence your decisions will only negatively impact your child. Your child has their own relationship with each parent that should be encouraged and valued. Now, let's talk about the possible outcomes of mediation. Over 50% of parents are able to work out a parenting plan in mediation. When an agreement is reached, the mediator will format the document and provide parents with a copy for review prior to leaving the session. If both parents verbally approve, the mediator will forward the plan to the judicial officer to sign, at which time it becomes a court order. Many times, parents may reach a partial agreement. This means that there are one or more unresolved issues in which both parents are proposing different options. One common example is the label of custody. One parent may be requesting sole custody, and the other parent may be requesting joint custody. In this case, the mediator will write up the parts of the plan that both parents are in agreement with and indicate that the court needs to decide the label of custody. At the end of this orientation, you will be directed to sign twice on the consent form. The first signature indicates you understand the process of mediation. The second signature allows the mediator to share the specific issues to be determined by the court when a partial agreement is reached. Although the ultimate goal in mediation is to reach a parenting agreement, sometimes there are circumstances or safety concerns that prevent this. When parents do not reach an agreement, the mediator may suggest several options to assist the court. One option is for parents to return for further mediation. This is helpful when parents have recently separated, or you may still be residing in the same residence. Sometimes a period of time is needed for everyone to adjust to the separation. The initial mediation session can provide education and options of different plans for parents to think about, and then they can return prior to the hearing or be referred the same day as your hearing to write up the plan. Mediators can also meet with your child. If parents express differing views of what their child has expressed to them, sometimes it's helpful for the mediator to speak with the child and then meet with the parents again to provide feedback. Mediators will use their discretion in deciding to interview a child. Typically, this occurs when both parents agree for the mediator to meet with their child. Mediators are trained to be sensitive regarding the separation process and never ask a child to choose sides between parents. In addition, information shared by the child would be confidential and not shared with the court. An attorney for the child may also be suggested in cases when the child is very young and cannot express themselves verbally, when there are medical or psychological needs, or if there are highly conflicting views by both parents regarding their children's preference. When an attorney is appointed for your child, they represent the child and would provide any needed information to the court. Parents are responsible for paying any attorney's fees. In cases where there is extremely high conflict or where there are safety concerns such as child abuse, drug and alcohol abuse, criminal history, or domestic violence, the mediator may suggest a child custody investigation or a 730 psychological evaluation. Custody investigations are completed by court-appointed mediators and consist of interviews with both parents and all children over the age of 6. In addition, police, social services, and criminal records are reviewed, and then a written report is provided to the court with recommendations for custody and visitations. A 730 evaluation is conducted by a community-based licensed psychologist who evaluates the parent-child relationship through interviews and psychological testing, and then provides recommendations for custody and visitation. Both types of evaluation are very costly, and the parents are financially responsible. When none of these options are applicable, then parents are referred to court, and the judge will decide what to do. Now that you know about the process of mediation, let's take a look at some emotional issues you and your children may be experiencing. It is important to remember that children love their parents. It is not their job to choose what type of contact they will have with each parent. It is your job as the parent to decide. Do not place them in the middle by questioning them about the other parent or asking them where they want to live. Try to separate your feelings about the other parent and focus on what your child actually needs. Research tells us that children need to have a positive, ongoing relationship with their parents. They need consistency and regular contact with each parent, yet this does not necessarily mean equal time. They need to feel emotionally and physically safe from parental conflict. Children who witness parents arguing or family violence become emotionally distressed. Children and parents as well experience a great sense of loss as a result of the separation or divorce. It is common to seek emotional support through counseling to adjust to the many changes you and your children may be experiencing. Now we are going to share some ideas about how you can support your children in order to minimize the impact of the separation. One of the most important things a parent can do is to respect and value the time your child has with the other parent. Be cautious about scheduling appointments or extended family events that may interfere with the other parent's time. Do not use the other parent as a reward or punishment for their behavior. Share information about your child with the other parent in a timely manner. This includes any information you may receive about school meetings or scheduling doctor's appointments. It also helps to share any changes in your child's behavior or health, such as having a high fever or trouble sleeping. Communicating on a regular basis and asking the other parent first if you have concerns about your child will most times prevent a simple situation from getting out of control. Children do better knowing when they will be spending time with each parent. Having a calendar in each home that is easily viewable by everyone helps to provide a visual of when the child is with each parent. The calendar system can be used even with very young children by assigning each parent a special color on the day they are with that parent. Children need to be reassured they are not responsible for what is happening and that they are not the cause of the separation. Depending upon the age of your child, you may need to repeat this message several times. Remind your children that you will always love them and will continue to take care of them. Just because they may not see one parent as much as before, doesn't mean they love them any less. Children may feel if their parents are separating, they may have to choose sides. It is important to give your children permission to maintain the relationship with the other parent and any extended family members. Do not be surprised if your child shares different thoughts and feelings with each parent. It is common for them to have conflicting feelings that often change from moment to moment. What do you say when your child asks you difficult questions about what is happening? It is important to acknowledge your child's feelings and reassure them it is not their fault. Be careful not to give too much detail. Keep in mind their age or maturity level. Although they may ask, it is not appropriate and can be harmful to share or allow them to read court-related paperwork. The most successful parents are the ones that have learned to cordially co-parent. It is our hope that you will develop a business-like relationship that focuses on working together to continue to raise your child to adulthood. The key is to understand and recognize that you are different people, and that you may have diverse points of view and parenting styles. This does not mean that one or the other is right. It only means that it is important to respect each other. Children can and do adjust to having two separate homes and sets of rules, just as the way they understand there are different rules in school. Each parent plays a significant role in your child's development and provides unique and valuable experiences. To lessen the impact on your child, it is important as adults to make decisions and communicate with each other. Do not place your child in the middle by creating a situation where they feel they must choose one parent over the other. Although it appears easy to relay information through your child, it places your child in an awkward position and may have unintended consequences. Try not to criticize the other parent at all, but especially when your child is present. Your child understands he or she is part of both parents, so when one parent is criticized, this negatively affects your child. The single best predictor of how well children adjust to the separation or divorce is based on the level of conflict between the parents. If the level is high, the outcome for children is poor. The best outcome occurs in families when there is no conflict between the parents. Research has shown that parents who can make decisions and develop their own custody schedule regarding their parenting plan are less likely to need future court involvement and are generally happier with the outcome. In addition, parents are more likely to work together, and this has a positive impact on the children. In conclusion, mediation is designed to help you as parents work together to develop a parenting plan that will unite you in the care of your children. We encourage you to think about a parenting plan that may not be ideal, but one you can live with. We hope you come to mediation prepared to compromise and reach an agreement. Thank you.